Good morning, Mr. Chapman.
Good morning, Your Honor.
You can proceed when you're ready.
Thank you. Before the court is Vincent Daniels. In each of these matters, Mr. Daniels is here today after failing to appear before this court on November 13th, 2019. In the first case, bond is currently set at $1,467. This is the seventh bench warrant. In the second case, bond is currently $500, and this is the second bench warrant. Front of the court's not aware of any employment information. The last payment made on these accounts was in March of 2020. Front of the court recommends that reasonable bonds be set on these matters and they be scheduled for hearing on September 11th, 2024 at 8:45 a.m. before this court.
Thank you. Mr. Daniels, you're before the court charged with civil contempt of court due to your failure to appear at a prior proceeding as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on September 11, 2024 at 8:45 a.m. You will get notice of that. Are you able to post a bond, sir?
Well, I've contacted my pastor. He said, yesterday he couldn't help out because the things was closed. But yeah, we was going to try to see if we can get it at a reasonable price to where I can pay it. I get paid on Wednesday, so I can start making payments. And I noticed, if I can say this, I noticed he said that I didn't make a payment. They took my taxes. I don't know where that went then. I thought they split it up between the cases.
Well, I don't know. We'll see, and that's something, but that's still that you're not making payments, even if they intercepted your taxes. So,
Yes, sir, and that's, well, I'm sorry.
You haven't paid in over 4 years, so.
Yes, sir, 'cause I was in jail in another state and everything, and I've communicated with the courts and everything, and I tried to get my address changed, and they said I had to do it a certain way. That's why I moved back, and then I just recently got a job at Milling and everything, so I get paid every Wednesday.
Where are you working at?
It's called Milling. It used to be AC Foundry off of Raymond Road.
Okay.
I poured metal over there.
Well, I'm going to reduce your bond, but I'm taking into consideration that you do have 7 bench warrants in the one case. I'm going to set in the 2013 case, I'm going to set your bond in the amount of $500. And then the other case, I'm setting in the amount of $200. So if you're able to post that, you'd be able to be released. Do you have any questions?
No, sir, that'll be it. Thank you.
Thank you. You're free to go. Have a good day.
Thank you.
0 DP. In each of these matters, Mr. Howlett is here today after failing to appear before the domestic relations referee on April 18th, 2024. In the first case, bond is currently set at $1,040. In the second case, bond is currently $837. In the third case, bond is currently $1,215. This is the second bench warrant in each case. Front of the court is unaware of any employment information at this time, but last payment made on these accounts was in November of 2023. Front of the court recommends that reasonable bonds be set in these matters and they be scheduled for hearing on September 11th, 2024 at 8:00 a.m. before this court.
Thank you. Mr. Howlett, you're before the court charged with civil contempt of court due to your failure to appear at a prior proceeding as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on September 11, 2024 at 8:00 a.m. Are you able to post the bond, sir?
No, so I got fired from my job at Speedway, and I just got employed at Brewers, Aluminum, and I just got a paper in the mail basically saying that child support is going to start garnishing from my new job. So I don't know if y'all can see that. Well, they sent me a paper to my house saying that they seen that I just started employment again. But no, I don't have no money right now. So
Okay. Well, you haven't paid in some time, so the court is taking that into consideration. If you are employed, the court would obviously like you to remain employed, but
just started.
Yeah. What I'm going to do is I'm going to cut you a break here, sir, but I am going to set your bond in each case in the amount of $100. So if you're able to post that, you'd be able to be released. Do you have any questions?
No, sir. Thank you.
Okay, thank you.
Okay. Well, I'm sorry. I do got one other question. Is it any way like I can be back referred to the program that I was in to work first?
Yeah, when you talk to your enforcement officer, they will arrange all of that.
Okay. Thank you. I appreciate it.
56 UE. In each of these matters, Mr. Jackson is here today after failing to appear before the domestic relations referee on July 5th, 2024. In the first case, bond is currently set at $675. In the second case, bond is currently $728. This is the first bench warrant in each case. Mr. Jackson, it appears, is employed at Denso. Last payment made on this account was on August 28th of 2024. That was through income withholding, which has been in effect since July 31st of 2024. Front of the court recommends that bonds be canceled in these matters, allowing Mr. Jackson to be released and return to work. Don't see a need for another hearing at this time.
Okay, thank you. Mr. Jackson, you understand what front of the court's recommending? What they're going to do is we're going to cancel the bond, and we're not going to have a hearing because you're paying through income withholding. So what happens, you'll be able to get out today, but it's going to take probably about an hour or so for all the orders to get prepared and entered before they can have you released, okay?
Yes, sir. Yes, sir.
Okay.
I appreciate you.
Okay, free to go, sir. Have a good day.
Mr. Tanner is here today after failing to appear before the domestic relations referee on May 16th, 2024. Bond is currently set at $1,405. This is the fifth bench warrant. Front of the court is unaware of any employment information. The last payment made on this account was in December of 2023. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on September 11th, 2024 at 8:45 a.m. before this court.
Thank you. Mr. Tanner, you're before the court charged with civil contempt of court due to your failure to appear at a prior proceeding as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your tenants at the next hearing on September 11, 2024 at 8:45 a.m. You will get notice of that in writing. Are you able to post the bond, sir?
Nope.
Okay. Well, court notes that you have not paid in, about almost 10 months. So the court is taking that into consideration. You have had 5 prior bench warrants. What I'm going to do is I'm going to set your bond. I am going to reduce it in hopes that you could be released. I'm going to set your bond in the amount of $500. If you're able to post that, you'd be able to be released. Do you have any questions?
No.
Okay, you're free to go. Have a good day, sir.
Ms. Timmons is here today after failing to appear before the domestic relations referee on April 25th, 2016. Bond is currently set at $592. This is the third bench warrant. Front of the court is unaware of any employment information at this time. The last payment made on this account was in February of 2016. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on September 11th, 2024 at 8:45 a.m. before this court.
Ms. Timmons, you're before the court charged with civil contempt of court due to your failure to appear at a prior proceeding as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your tenants at the next hearing on September 11, 2024 at 8:45 a.m. Are you able to post a bond, ma'am?
No.
Okay. Well, court notes, obviously you haven't paid in, over 8 years. So the court is concerned about that. And, your last payment was, again, over the same amount of time. So you haven't made any payments in this matter. Court believes that the bond at the amount of $592 is reasonable. I'm going to continue that bond. You're free to go. Have a good day.
At 8:44 a.m. Attorney Payson for the plaintiff.
That's all I have for today, Your Honor.
Good morning, Ms. Payson.
Good morning, Your Honor.
So you said you have the parties, they did sign the judgment for custody, all that, except not the UCSO?
It is, Your Honor. They had originally agreed to deviate for no child support. Neither party wanted child support. However, when we submitted it to the front of the court, it was denied because mom has state aid for the child in regards to health insurance. So we prepared a deviation to just have it be the ordinary medical. It was approved by the front of the court, but we have attempted to reach out to mom on several occasions, leaving messages at the beginning of August on the 2nd, August 1st, August 6th. We've sent her emails. We've sent her the agreement via Adobe to sign, and we have not heard anything from her. So I'm just asking that this court enter the support order and deviation that was submitted to the court, having her just pay the $25 for ordinary medical as required.
Court notes that it is now at 8:44 a.m. It was set for 8:30 a.m. The defendant has not appeared, so the court will enter the orders as submitted in this matter, and that will conclude the case. Thank you.
Thank you, Your Honor.
Henderson for the plaintiff.
Good morning to everyone.
Good morning, Your Honor.
Ms. Wolf, we're going to take some testimony from you. So if you would raise your right hand, we'll have you sworn in, then we'll proceed.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Go ahead, Ms. Henderson.
Thank you. Could you please state your full name for the record and spell your last name?
Wolf, W-O-L-F.
Ms. Wolf, did you consult with myself in beginning of 2024 regarding filing for a divorce?
Yes.
Have you in fact signed the complaint for divorce on or about February 16, 2024?
Yes.
And at the time you signed the complaint, were all allegations therein true and accurate to the best of your knowledge?
Yes.
Do they remain true today?
Yes.
At the time of filing for divorce, have you resided in the state of Michigan for 180 days?
Yes.
And in Calhoun County for 10 days?
Yes.
Are you currently pregnant?
No.
In your complaint, you stated that there has been a breakdown of the marital relationship to the extent that the objects of matrimony have been destroyed and there is no reasonable likelihood that the marriage could be preserved. Is that correct?
Correct.
Could you please briefly state to the court what led to the breakdown of your marriage?
18 years of repeated marital affairs on Curtis's part.
If the judge were not to grant the divorce at the time we receive front of the court approval, is there any reasonable likelihood that you would reconcile?
Absolutely not.
May it please the court, Your Honor? The parties have signed a consent judgment and support order, Your Honor. We're just waiting on FOC approval.
Okay, Mr. Wolf, just to confirm, you have signed all the consent judgment in the UCSO, is that correct?
Yes, sir.
Okay, thank you. Court will find that the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship. The court will preserve the proofs pending front of the court approval. You're not divorced until I actually get that approval and then sign the judgment. So it may take just a matter of a few more days or a week or so, but we'll get that entered as soon as we receive it. You'll be divorced at that time. So best of luck to both of you. You're free to go. Have a wonderful day.
Thank you,
Thank you, Your Honor.
At 9:56 a.m., Attorney Cindy Thomas for the parties as a consent.
Okay. Good morning to everyone.
Good
Good morning.
What we're going to do is take some testimony from you, Mr. Michalka. So we have you raise your right hand, be sworn in, then we'll proceed.
Do I correct? Yeah. No.
Or do you-
Sorry, the last name is pronounced Mahalka, just FYI.
Mahalka,
Oh.
okay.
Yes. Yeah.
All right. Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes.
Okay. Go ahead, Ms. Thomas.
Thank you. Dr. Mahalka, do you recall signing a petition in this matter for this collaborative divorce?
Yes.
And at the time that you signed that petition, was everything in the petition truthful?
Yes.
And is it still truthful today?
Yes.
To the best of your knowledge, is Mrs. Mahalka pregnant?
No.
You had indicated in your complaint in your petition for this collaborative divorce that there had been a breakdown of the marital relationship to the extent the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Is that correct?
Correct.
Can you please briefly describe to the court what caused the breakdown?
We just went our sort of separate ways, grown in different ways.
Okay. And if the judge were to not sign the proposed judgment of divorce, would you and Mrs. Mahalka be able to fix your differences, if you will, and again, live together as husband and wife?
No.
You've, in fact, as through the collaborative process, you've reached an agreement as to all issues. Is that correct?
Yes, correct.
And you believe that as to the property issues, that everything is equitable?
Yes.
And in addition to that, now this was filed as a DM case because at the time that we filed, your daughter was a minor, but she just turned 18 yesterday.
Correct.
So that's why we're finishing this out earlier than the 6-month time frame, simply because that she is now an adult, correct?
Correct.
Okay. And you're asking that the judge actually sign the judgment of divorce and all of the additional documents that are in front of him to complete this matter, correct?
Correct.
May it please the court?
Court is satisfied that the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship. The court will enter the consent judgment and the paperwork in this matter as soon as I receive that. May take yet a few days till that gets to me and gets it signed, but we will then get it entered and that will then conclude your divorce. Best of luck to both of you. I hope everything works out for you and you're free to go and have a wonderful day.
Thank
Thank
you.
you.
Thank you.
All right. Thank you.
Court will note the appearance of Mr. Todd on behalf of the plaintiff, Mr. Sullivan on behalf of the defendant. This matter is before the court on the two motions of the plaintiff, a motion for temporary parenting time, custody, exclusive use and possession, and a motion for a mutual temporary restraining order concerning assets. Mr. Todd.
Thank you, Your Honor. Your Honor, I'll start with the mutual restraining order. I've read Mr. Sullivan's response, and the reason we requested the mutual restraining order in part is that the opposing party was spending $250 to $300 at party stores, which became approximately $1,000 a month. She requested this stop, and it didn't at that point. The parties created individuals' accounts. In May, he moved $12,000 from the joint account into his bank account, and then she moved $12,000 into her individual account as well. Prior to speaking with an attorney, she then moved $130,000 into her saving account. She is totally fine putting back $118,000 into the joint account, which is the just less than $12,000. So she's totally fine moving that $118,000 into the joint account as long as the mutual restraining order is in place. Currently, there is $52,000 in the joint account. Additionally, in relation to their response, she's transferring money into the joint account. She's transferring half of the amount that it would be for the bills into the joint account. So we do believe that it's appropriate that the mutual restraining order exists. And if that happens, my client is certainly happy to, again, return that $118,000 back to the joint account. And do you want me to go into the other motion too as well?
Well, let's have Mr. Sullivan respond. Mr. Sullivan, you've heard Mr. Todd. Does that resolve issues on the, I guess, preliminary injunction?
A couple of points. First of all, Mr. Todd begins with the assertion that my client was spending X amount of money at a liquor store, and that was the basis for filing the petition for ex parte order. As he was saying that, I reviewed the ex parte motion, and there's nothing in the motion that suggests that at all. So that seems to be a curious statement today when it wasn't pled initially. And
okay, well, let's get past that because I didn't grant the ex parte anyway, Mr. Sullivan.
Well, fair enough, but I don't see that ever has been presented as a basis, and it's hard to respond to that when it just comes up this morning.
Okay.
Secondly, we don't have an objection to the issuance of a mutual restraining order. What we would like to see is an accounting by each side that can be done in connection with the filing of the domestic financial information form that indicates who withdraw what amount of money at what time. So that's what we would ask for. I don't think we're apart on this issue.
Okay.
No objection, Your Honor.
Okay. Court will grant a preliminary injunction at this time, enjoining the parties from disposing of, secreting, I guess you'd say, in any way hindering their various assets. Court would allow, as Mr. Todd has suggested, that the plaintiff would transfer $118,000 back into the joint account, and then would you be able, Mr. Todd, your client, be able to account for those withdrawals, et cetera, within 30 days, let's say?
Your Honor, I guess if we could have 45 days just to be on the safe side.
Okay. Mr. Sullivan, would your client be able to comply within 45 days?
Yes, and
okay.
Yes, Your Honor.
Okay.
I did have one thing to add. And I've communicated with Mr. Todd about this issue, but my client is in the process of ending a lease on a truck. He's going to need to have another truck. My plan is to work with Mr. Todd on that, and perhaps if necessary, enter a consent order to allow for him to get a different truck. And if that necessitates some jockeying of money, then we'll make that work, Your Honor. Would you agree, Mr. Todd?
Why don't we just do that, Mr. Sullivan? If in the event your client needs to take money out of the joint account to acquire, as far as the money down on a vehicle, that Ms. Logan would be entitled to receive an equal amount as a withdrawal as well.
Yeah, no objection.
Okay, go ahead, Mr. Todd. You can prepare that and you can proceed with your other motion.
Thank you, Your Honor. In terms of the, probably makes sense to start with the house. Miss Logan is currently pregnant. She's in a high-risk pregnancy because she had a prior cesarean section and is a diabetic. So the stress changes in her cortisol levels, which can cause changes in her sugar levels, and this can actually have a significantly negative impact on the fetus in terms of issues with the heart. We've attached some verification as an offer proof to our motion. And so the physician actually recommended that Mr. Logan move out of the house. Additionally, Miss Logan cannot live with her parents. They have 4 dogs and she has 3 dogs, or they have 3 dogs. Unfortunately, that's simply not feasible. However, Mr. Logan has another house in town that he owns. And additionally, his parents also live in town, so he could live with them as well. So we are respectfully requesting exclusive use and possession of the home be granted to Miss Logan. And I'm happy to continue forward if you want with my custody portion.
Yep, go ahead.
Thank you. In terms of custody, Miss Logan has always done she's been the primary caregiver. She has done all the drop-offs for the minor children's school or daycare and has absolutely been the primary caregiver. Mr. Logan has a substantial history of alcohol abuse. Upon returning home from work at 7 or 8, he will usually start drinking. That unfortunately has continued even since he has been served with this motion. Even within the past few months, he went to a high school reunion and passed out in his car. His parents needed to pick him up. This is just an indication of how the alcoholism has continued. Additionally, he does have an OWI in his history. Mr. Logan's work schedule, in essence, prevents him from being able to parent a 2-year-old child just turned 3. And anything more than the Calhoun County standard parenting time, we don't believe would be anything he could actually even use. He was fired in April, and since that point, he has not been picking up the child. Just actually after being served this motion, he has started picking up the child once in a while. But again, Miss Logan has always been the person who has picked up the child, with the exception of always been the one who dropped off the child and has picked up the child with the exception of a few weeks. It is accurate that Mr. Logan plays with the child, but unfortunately, that's all he does. He does not bathe the child. He does not provide the child food. He doesn't do anything like that. He does not take the child to appointments or schedule appointments or anything of that nature. Additionally, in relation to the response, the alleged reason for the breakdown is not just an attraction issue. That is one reason, but the reason for the breakdown is unfortunately Mr. Logan's alcohol addiction, and additionally, he has been cheating on her and unfaithful, and that's the reason for the breakdown. Additionally, unfortunately, relatively recently, Mr. Logan's parents were watching the child, and then upon drop off to Miss Logan's house, they berated Miss Logan about the divorce in front of the child. So we are respectfully requesting that the court remind everybody to not have any discussion in front of the child. So we are respectfully requesting that Miss Logan or Mr. Logan have the Calhoun County standard parenting time provided for children from 3 years old until entry of kindergarten. We did change this from our original request because the child did turn 3. So we are respectfully requesting the court order that, and we would request that midweek visit just be once a week on Wednesday. Lastly, we did include in our motion that Mr. Logan's brother not have contact with the minor child because he does have he is on the central registry for CSC.
Okay, thank you. Mr. Sullivan?
A lot to respond to, Judge. I want to start out with the presumption under law, and the presumption is that joint custody is presumed to be in the best interest of the minor child. My client's position is that the parties have equally provided joint care of the minor child. My client's position is backed up by testimony that should we have a hearing, would offer the paternal grandparents say that the care was equal between the two of them. And as indicated in my pleadings, Judge, my client did work at Semco until just recently. When working at Semco, he always provided the pickup, the care after school or after daycare, and the care in the evening, early evening part particularly, and then they joint cared in the evening. So the care was equal, if not more, in favor of my client. So for the plaintiff to assert otherwise and simply focus on who took the child to daycare at the beginning, ignoring all the afternoon and early evening time and then the joint care in the evening, is disingenuous and is mischaracterization of the facts. Again, joint custody is presumed. They're still together. They still have equally co-parented. And for that reason, that shouldn't change simply because Miss Logan wants a divorce. It is in the best interest of the child to continue to be in equal care of both parents. Now I want to talk about this claim of the drinking. There were 2 assertions in the motion filed by plaintiff. One was that my client had a OWI of sorts in his history. That's true. But as I've indicated in our response, Judge, that was 14 years ago, 12 years before Wyatt was born. To suggest that that has any relevance to today's action is just illogical. Secondly, today, Mr. Todd asserted that he consumed too much at a reunion. That's not accurate. There was a union meeting as pled in their motion. He did consume too much alcohol in April of 24. He did the right thing and didn't drive home. To suggest that one occasion of consuming too much alcohol is a reason to not award joint legal custody to 2 parents who have equally co-parented is, again, illogical. The plaintiff makes a number of allegations, none of which is supported by other than what the plaintiff alleges. We, on the other hand, allege the opposite, and they've lived together since the child was born, and they've equally co-parented. We're asking that you issue a joint physical custody order. Wanted to mention about the ailment that is alleged by plaintiff. We have text messages wherein plaintiff texted to paternal grandmother that, this is a bit of an oddity, but plaintiff will not communicate with my client about the pregnancy and the prenatal care. She will, however, communicate with paternal grandmother, and she did just recently communicate that all things are going well in the pregnancy. So that's not consistent with the assertion that there's a stress level that's impactful at the present, because it's not, as affirmed by Ms. Logan. So we're asking that my client retain the home, that my client have joint physical custody of the minor child.
Okay, thank you. Mr. Todd, any response?
Just very briefly, Your Honor, my apologies. That was a union issue. However, he in essence, told my client and the child he was going to return home that night. And he failed to do so, drinking excessively to the extent that he passed out in his vehicle. Again, just indicating how significant the alcoholism problem is. Additionally, he will continue to drink after he returns home, which is not until 7 or 8 o'clock at night. So we believe it's absolutely relevant. In terms of my client's pregnancy, the closer this comes to fruition, the more important it is to remain her A1C levels to remain intact. And her indication to the opposing party's mother that pregnancy is going okay, that's because she's trying to manage these levels as much as possible. But again, we have a physician note requesting, in essence, that she be given exclusive use and possession of home.
Okay,
Nothing
well,
further, Your
Mr.
Honor.
Todd, as you might know, court doesn't consider the physician's recommendations as to exclusive use of the home, so.
I understand, Your Honor.
Okay. Well, what the court's going to do is the parties still are together in the home, so the court is going to, at this point, the court is going to grant to the parties the joint physical and joint legal custody of the minor child. The court will, at the time that the parties do separate, the court will put in place a parenting time of a 2-2-3 schedule for the parties. Court will order support consistent with the that schedule when the parties have separated. And in this matter, the court will, at this point, is based upon what is stated. The court doesn't believe it's appropriate that the parties continue to remain together. In this matter, the court will grant to the plaintiff the exclusive use of the home and order that the defendant would vacate in 45 days from today's date. Court would order that when the parties have the child in their particular care, that they would not consume any alcohol. So, sir, at this point, there's just been allegations, and that's all they are at this point. But I will let you know that, again, should it come up that there is drinking when, again, you have the child in your care, that the court could utilize that as a basis to, in fact, make a change in the custody and parenting time. So, Mr. Todd, I'll have you prepare that order, submit under 7-day notice of entry.
Thank you, Your Honor. I apologize, Your Honor. Just one question. Mr. Logan's brother is.
Oh, yes, I did. I wanted to address that. I didn't.
Okay.
I'd place that his brother, Justin Mark Logan, would not have any contact with the child. So, sir, I understand that you may have some issues, but if you're at your house or at your parents' house and the brother comes along, you have to leave because I don't want him having any contact with the child. Okay, thank you. You can include that, Mr. Todd.
Thank you, Your Honor.
Okay, have a good day.
Thank you.
Court will note the appearance of Mr. Todd on behalf of the defendant. This matter is before the court on the defendant's motion for contempt. I just have a question, Mr. Todd. Is obviously the court has not entered an order stating that the child had to see a trauma specialist. How can I hold the plaintiff in contempt if I have no order?
Yes, Your Honor. I believe the prior order indicates that the parties would use blind counseling and their recommendations. And it's the recommendation from blind counseling that the child see a child trauma specialist.
Okay. Well, Ms. Roush, just to clarify, they're asking that the child would see a trauma specialist. Do you have any objection to that? You're muted, ma'am. You're going to have to unmute.
Can you hear me?
Yes.
No, I don't object to that. And we have been in the process of seeing a trauma therapist. Josh, our reunification therapist, has said he has been updating them about this because I've had to call 5 different trauma therapists and I have not got a phone call back. And he is aware of this because he could not reach out to them either. I have already found a trauma therapist and we've done an intake, and Chase is currently on a waiting list to be seen because that is how this works.
Okay.
There was a delay because they said an appointment could not happen before 3 p.m., which I thought taking him out of school for this was a little ridiculous, but here we are, and I still am setting up an appointment, but he will have to miss school twice a month in order to do this trauma therapy.
Okay, well, that's fine. And Mr. Todd, is that are you aware of all that or not?
I'm aware of some of that, Your Honor, and to be honest, what ended up happening is there was a specific child trauma therapist recommended through Blind, and until we filed this motion, basically very little had happened.
Okay.
So
I understand, but as she stated, and I don't know, at some point, if we have an evidentiary hearing, we'll have to address that, but she stated that there's been a lot of difficulties in getting into a specialist. So what the court will do is the court will order that the child would be seen by a trauma specialist in this matter. Ms. Roush, what is the name of the individual whom you have an appointment with?
It's through Comfort Counseling is the trauma therapist place. And her name is Shelly. I don't have a last name at the moment.
Mr. Todd, if you can include that in the order.
yes, Your Honor, I guess, can we include a time frame just to make sure that this doesn't, linger?
It's very hard to do a time frame, as in the paperwork stated, you put the trauma therapist was needed on 6/2. Our first appointment with Josh, the reunification therapist, wasn't until the end of May. July was when he suggested a trauma therapist, because that is when Chase started bedwetting and having night terrors due to this reunification therapy. So also, this is not based on my time frame. It is based on Chase, the child, who is going through this. And there was a setback because he was dealing with that.
Okay.
And we have moved forward, and there have been appointments made.
Okay, you have appointments set then?
No, he's on a waiting list, and they call me when there's an appointment available, and we take it.
Okay, why don't you just state, Mr. Todd, put in it that the parties would have the child in at the first available date, and that way we can make sure that it's expedited in some way. But obviously, the first available date's not for 40 days. I can't say, well, do it within 30 if they can't.
Right.
So, Mr. Todd, you can prepare the order and submit under 7 day.
Thank you, Your Honor.
Thank you. all.
Also,
Yeah.
one more thing. Because the last hearing, we stated that I no longer was represented by Katie Reed,
Yeah.
and I had to email you my information. Can you guys please send me this information and stop sending it to Katie Reed?
Yeah, I will send that directly.
Thank you.
Okay, thank you. Have a good day.
Thank you, Your Honor.
You too.
Savage back in the waiting room. Cindy,
Yes.
is this, we got some problems with the where v where,
I understand. We noticed it wrong. It was our fault.
but what happened is unfortunately the order got entered.
Right. So we're going to have to set that aside because Mr. Schaefer has a right to his objection. And even though the notice did say 7 day and it did say that it also had date certain, and because it wasn't within the last 7 days, we inadvertently used the wrong precedent form as opposed to the date certain when we used the 7 day, and we should not have. And I didn't realize that until Friday night when I was prepping for today.
Okay,
I
well,
go forward with that analysis. That's correct.
we didn't realize it until this morning because the clerk didn't put it on our schedule at all until this morning. So we're in the dark as well. And
Right.
so, Mr. Schaefer, does that take care of the issue if, again, we set aside that order?
Yeah, I think pursuant to the order signed by Your Honor on 4/25, that if we can't come to an agreement in relation to the support that needs to be set for an evidentiary hearing, that's what the language of the order is.
Okay.
And I think we're at that stage.
Okay.
I would agree with that, Your Honor. I hate to have an evidentiary hearing when in fact we have all of the tax returns, and the tax returns show that the total income are the numbers we use. The only thing we added in other than what the business income was, Mr. Ware's share of the business income was the $2,012 from the depreciation of the farm from the special depreciation, over and above the amount over and above the special depreciation of the farm, which is an additional $2,012. We used the numbers that Mr. Schaefer provided to us and included that $2,012. That's what we did, was use a tax return.
Okay, well, what we'll do, Ms. Thomas, I ask that you would do an order setting aside that order.
I will.
And the court will refer the matter of support to the referee for a hearing. And obviously with the time wise, you're going to end up with probably about 30 to 40 days before that hearing comes up with the referee. And if you can get the matter resolved prior to that time, then you can simply contact the referee and see if you can't, cancel that particular hearing. If not, then you can proceed with the hearing.
Okay, perfect. Thank you.
Okay. Thank you. Thank you. Have a good day.
Thanks.
2024 at 9:36 a.m.
Court will note the appearance of Ms. Basson on behalf of the plaintiff. This matter is before the court on the plaintiff's motion for entry of default judgment of divorce. Ms. Basson.
I'll be paying again. I'm pitching you. Choose from me or Dr.
Whoever has TV or something going on in the background, please mute that so we don't hear it.
Submit this motion pursuant to the default that was entered earlier this summer. She's already provided proofs on the record, both as to the dissolution of the marriage, as well as her intent to submit a default judgment of divorce that is equitable as regards property. While there is a minor child between the two parties, there is no issue of custody in this case due to the termination of defendant's parental rights, and therefore plaintiff asks that this motion be entered. Thank you.
Okay, thank you. Mr. Merrithew, what's your response?
Please unmute.
Okay, yeah, I'm not disputing the divorce at all. I agree with the paperwork that was provided to me, other than there was a couple of questions of I guess property that I don't know about that I have to go to a police station to pick up. But other than that, I really don't have anything that I disagree about.
Okay. Well, if there is property that she wishes to return to you and she has a setup under the judgment that you'll meet, that's up to you. If you don't meet, you don't get the property. If you meet, then you can get it and then have the property at that point. Maybe something that you don't know that you want. I don't know, but if you meet up, then you'll get it. If not, then you'll waive any right to that property. So,
from what I understand, the paperwork states I have 30 days to set it up with her attorney.
Okay.
Which I have no problem doing. There's actually an itemized list of everything that she has. Everything not on the list, it's already gone. So I'm not gonna waste the court's time over things that are no longer in, possession.
Well, we appreciate that, sir. Just at this point, set up with Ms. Basson where you'll set up a date where you can arrange to meet and pick up that property if you wish to do so. Okay?
Okay. How do I get in contact with her?
Sir, you have my phone number as well as my email you've used several times. I'm happy to give that information again if you need it. But.
Please, I just wanted so it's clear and I don't send anything to the wrong place.
My phone number is 517. That's all on the paperwork. That's on the first page of judgment of divorce as well.
Okay.
Okay.
Thank you. I just wanted to make sure it was correct. Thank you.
Okay. Thank you. You're free to go. Have a good day.
Yes, you too.
Judge, can you just clarify that you are signing the judgment of divorce and the parties
I
are
will
now
as soon as they
divorced?
forward that to me.
Thank you so much.
At 10:03 a.m.
Okay, Ms. Savage, at this point, your client's not joined back up. It's all right. We proceed, or do you want to wait until she is joined again?
Well, Your Honor, what we were hoping to do is preserve the proofs today and adjourn the motion hearings out for 3 weeks in case we need them. But we expect to present a consent judgment to the court in advance of that time.
Okay. Why don't we do this? We will.
I'm not sure where she's at.
Mr. Elmoff, if we let you and your
There she
client
is.
go.
I see her.
We'll let you and your client go if you wish, and then we can take proofs. Do you have any problem with that?
No problem, Your Honor. I do have one more hearing this morning.
Okay. Well, we'll put you in the waiting room, and Mr. Gross, you're free to go, and then you have a good day, sir.
Thank you, sir.
Ms. Gross, we're going to take some testimony from you, so we'll have you raise your right hand and be sworn and take yourself off mute. Okay.
Please raise your right hand. Ms. Gross? Can you hear me? She's from. Do you solemnly swear or affirm the testimony you're about to give shall be the whole truth and nothing but the truth?
We can't hear you, ma'am.
I do.
Okay, thank you. Go ahead, Ms. Savage.
Your Honor, just so the court's aware, there is a lag in Ms. Gross's responses that we were experiencing that in the breakout room as well.
Okay, go ahead.
Ms. Gross, you signed a complaint for divorce earlier this year, correct?
Yes.
When you signed it, was everything in it true?
Yes.
Is it still, everything in that complaint still true today?
Yes.
When you filed it, had you been a resident of the state of Michigan for 180 days and the county of Calhoun for at least 10 days?
Yes.
In the complaint, you indicated there had been a breakdown of the marriage relationship such that the objects of matrimony had been destroyed and there remained no reasonable likelihood the marriage could be preserved. Was that true then, and is it still true now?
Yes.
Do you and Lucas have minor children of your marriage?
Yes.
Would you please state your minor child's name and age and spell her name for the record?
Age 12.
Now, you've reached an agreement with Mr. Gross respecting all aspects of your divorce, correct?
Yes.
Does your agreement equitably divide all of your property, including your debt?
No.
I'm asking about the agreement that you've reached, not necessarily the default judgment. Does the agreement equitably divide all property and debt?
No.
Ma'am, you have to propose an equitable judgment to the court. Is the agreement that you've made equitable, in your opinion, meaning fair?
No. But I agree to it.
Is it, Your Honor, I'm not sure if you can help me here. Is it,
Ma'am, you've stated that you are agreeing to this, so you're consenting to the judgment, and the attorney's just trying to determine whether you believe it's fair. It may not be something that you like, but if it's fair and reasonable, then the court can enter that. And that's what she's asking you.
Yes.
Okay, thank you.
Your Honor. Stacy, does your agreement also resolve all issues of custody, parenting time, and support?
I believe so.
Have you both agreed to waive spousal support?
Yes.
And do you understand that by agreeing to waive spousal support now, it will be forever barred and you can't come back and ask for spousal support later?
Yes, I understand that.
Are you currently pregnant?
No.
Are you seeking to change your surname?
Yes.
Would you please indicate to what and spell that for the record?
McCready?
Based on the information you've just placed on the record, are you asking the court to preserve your testimony and then enter a consent judgment of divorce if and when presented?
Yes.
I have no further questions, Your Honor.
Thank you. The court is satisfied that the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship. The court will preserve the proofs pending the receipt of the approved judgment. When I have that, we'll approve it. Ma'am, so you're not divorced until I actually sign that paperwork, which may still take a few weeks, et cetera. So, but best of luck to you, and I hope everything works out for you. You're free to go. Have a wonderful day.
Your Honor, thank you for
Thank you.
Yes.
Yes, ma'am.
Can you see the screen?
Yes, ma'am.
Is this Tevin Cannon on the screen?
My last name is Cannon. His last name is Wines.
I'm sorry, Tevin Wines. Tevin, can you?
Is Mr. Wines on the screen, ma'am?
No, ma'am. No, sir. Sorry. I don't see it. It has two people in the waiting room.
All right. Sir, can you hear me? Sir, you need to connect to audio.
Can you send him a message?
I've sent him several messages.
Okay.
We do not have Tevin Wines in the waiting room.
Okay, then
So,
put him back in the
calling-
waiting room and then we'll go to
Yes.
Mr. Umloff.
Calling case 2018-17.
Court will note the appearance of Mr. Umloff on behalf of the plaintiff. This order is noticed for entry in this matter. We'll note that it is now 10:11 a.m. and the defendant, Mr. Wines, has not appeared. As a result, the court will enter your order, Mr. Umloff, as presented. Is there anything else?
No, Your Honor, thank you.
Okay, thank you. Free to go. Have a good day.
Thank you.
Thank you. Same to you.
So Christie, do you think Martin's getting renoticed? Or
Yes,
people here?
that one is
Court will note the appearance of Ms. Oatman on behalf of the plaintiff. Do I have an appearance on behalf of defendant?
Yes, good morning, Your Honor. Emma Green appearing with and on behalf of Matt Klein, the defendant.
Okay, great. This matter is before the court on the plaintiff's motion to enforce judgment of divorce. Ms. Oatman.
Yes, Your Honor. As we stated in our motion, we are seeking enforcement of prior orders. This judgment, the pleading started in 2021. As stated in our motion, the defendant has not accepted or abided by this court's orders. At any step of these proceedings, last year he was ordered to turn over the items we listed in our motion. At that time, the court had already determined that no further personal property disputes would be decided. We believe that defendants' requests for relief should be denied because of that order back in May of 2023. However, plaintiff is merely requesting this court find defendant liable for the fair value of the items he was already ordered to provide to plaintiff, in fact, more than once. So what we are seeking is financial compensation for that personal property that was wrongfully withheld and attorney's fees within 30 days of this hearing if this court decides that that is appropriate.
Okay, thank you. Ms. Green, what's your response?
Yes, so the parties had their exchange back in May of 2023. Mr. Klein brought everything in his possession that he had. Some of the items had been in a cabin that was solely and exclusively under the control of Ms. Klein. So obviously he didn't have access to those, but he brought everything he had. At that exchange, she refused many of the items. She didn't think that he brought everything. They've submitted a video, and in that video, it shows that there's boxes. We've provided pictures. He brought everything that he had. At this point, he's offered to just call it a wash. It's been a year and a half. There's property he didn't get either, to the tune of about $14,000. But he's saying, you know what, look, it's been a year and a half. We've got what we've got. Let's move forward. We've wasted a lot of time on this personal property.
Well, apparently the plaintiff's not in agreement with that, Ms. Green. So what are your thoughts?
I mean, he still owed about $14,000 worth of personal property. So in our response, you know, if we want to go down this road, he's saying, great, you know, I'll pay you your money, but you're going to pay me more money, which is why he thought the wash was an appropriate response.
Okay, what the court will do in this matter is the court will order that, again, any and all personal property awarded to the other party would be exchanged on Saturday, September 14th at 12 o'clock noon. And that would include the keys to the safe that apparently or allegedly the defendant has in his possession. And again, the court will order that the personal property that is in fact not exchanged, that the opposing party would be awarded a money judgment in this matter for the amounts contained in paragraph 5 of the plaintiff's motion to enforce judgment. The court will reserve on the attorney fees at this particular point. And I'll ask Ms. Oatman that you would prepare an order to that extent. And hopefully we can get the thing resolved. If there is any other personal property that plaintiff has in her possession belonging to the defendant, that she can in fact exchange that on the 14th as well. So, okay, thank you. You're free to go. Have a good day.
Thank you, Your Honor.
At 10:40 a.m.
Good morning to both of you. The court will note that this matter is before the court on the defendant's objection to the referee order in this matter. The referee order was entered on June 7, 2024. And sir, your objection was not filed until August 15, 2024. And if you note in the order states that that order will become final if an objection and notice of hearing is not filed within 21 days from service of the mailing date. The mailing date was June 10, 2024. So your objection is untimely. So what do you have to say, sir?
Yes. I tried to they were supposed to mail the letters to me so I could object, but I didn't get them for, a long time. And
well, they were mailed out to you on June 10th, 2024, and there's a proof of service in the file showing that they were mailed out on June 10th. And now maybe the post office was slow, but they wouldn't be that slow because your objection was not done until August 15th. So that was like 2 months after they were mailed to you.
Okay.
Well, so what it means is that your objection's untimely, and as a result, the court cannot entertain your objection because it's not a proper objection having not been filed within the appropriate amount of time. So I'm going to have to deny your objection, sir. Ms. McCray, is there anything else you have?
No, not really.
Okay. Okay, thank you. That will conclude the matter. You're free to go. Have a good day.
Okay, thank you. Bye-bye.
2024 at 10:43 a.m.
Court will note that this matter is before the court on the plaintiff's motion to set aside referee recommendation in this matter, and you had filed your objection. The court did have an opportunity to review the referee finding in this matter, and the referee had basically stated that you had not established by clear and convincing evidence sufficient proofs to change the established custodial environment in this matter. Do you have anything else, ma'am?
Yes, I have more proof. I just didn't know when I tried to bring it up there before this court date, they said I wasn't allowed to bring it. My daughter had talked to the police officer about everything that went on.
I don't need to get into the specifics about this because, again, if you don't bring up a evidence at the time of at the hearing, then the court can't consider. I can't go back and say, "Oh, geez, you should have brought this up, so I'm going to let you bring it up now." What happens? You can set aside the referee recommendation if the referee made a legal or factual error, and you haven't established that he made a legal or factual error. So what's your response? Is there a legal or factual error?
Yes, we never had another hearing like we were supposed to. He just signed off and gave Edward back the children.
Okay. Well, all I can tell you is basically when you bring it in is the court has to look to see, is there a legal or factual error? And based upon my reading of the referee's ruling in this matter, I cannot establish that he made a factual or legal error. And if he didn't, then the court cannot grant your motion. So unfortunately, I'm going to have to deny your motion in this matter. So the court will do the denial, and that will conclude the case, ma'am. So you're free to go. Have a good day.
Good afternoon, Your Honor.
I did get your alternate service order in that this morning, signed it, so that should be coming out to you at some point.
The sheriff tried serving it 5 times, and someone was there and confirmed that he was there, but after the first time they answered the door, they wouldn't answer the door again. So
okay.
He's
well,
ducking
I put down that you'd leave it. I had added to it to leave it at with someone of suitable age and discretion, but if he goes back and they won't answer, let us know. We can always modify that.
Okay. Very good.
Probably nothing. Why don't we do is we'll set this out for maybe 45 days and hopefully we can get service and have something more when we come back.
Okay. Very good, Your Honor.
Okay. Have a good afternoon. Bye.
You too. Bye-bye.
All right, thank you. Okay, Judge, this next one is the Maisner. So we're gonna take the proofs. They have a stick for that. And I'll send you the orders. I do have them in the system here.
Oh, you do have the orders?
Yes, we do.
Okay.
So let me send those to you real quick here, 1:30 p.m. Attorney Court for the plaintiff.
Good afternoon to both of you. It's my understanding, Ms. Greenlee Core, that we're going to be taking proofs and that you have resolution.
That's correct, Your Honor. I did mail in the judgment with the approval, so hopefully the court has it.
We do.
Perfect, yes.
Mr. Maisner, we're going to take some testimony from you. So we're going to need to have you raise your right hand, be sworn in, and then Ms. Core will proceed.
Sir, do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes. Okay. Go ahead. You can put your hand down, Ms. Core. You can proceed.
Thank you. Mr. Maisner, you originally filed this case yourself, is that correct?
Yes.
At the time you signed your complaint for divorce, had you been a resident of the state of Michigan for at least 180 days?
Yes.
A resident of the county of Calhoun for at least 10 days?
Yes.
And were there any minor children born of this marriage?
Yes.
Can you state the names of those minor children, but not the birth dates? And
Riley.
is there any chance your wife could currently be pregnant?
Not that I'm aware of, no.
Okay, so not to the best of your knowledge, information, or belief?
No.
Okay, and has there been a breakdown of your marital relationship?
Yes.
Can you give the court a brief reason for that breakdown?
Infidelity.
And if this court were to deny your divorce for any reason, would you go back to living as husband and wife?
No.
And you remember signing a consent judgment of divorce?
Yes.
Do you believe the property settlement in that judgment of divorce is fair and equitable?
Yes.
Do you believe that the parenting time in that judgment of divorce is in the best interest of your minor children?
Yes.
You understand that the spousal support provisions in that judgment of divorce are not modifiable. You can't go back later and ask for spousal support.
Yes.
And you understand that the rest of that judgment of divorce is also not modifiable. You can't change your mind tomorrow and come back later and try to modify it.
Yes.
Thank you. Nothing further, Your Honor.
Court is satisfied that the testimony does establish a statutory basis. There has been a showing there's been a breakdown of the marital relationship. The court will enter the consent judgment as provided in this particular matter. Sir, you are divorced then, and best of luck to you. I hope everything works out, and you're free to go. Have a wonderful afternoon.
Thank you, Your Honor.
Thank you.
Okay, thank you. And we will close the record here.
Thank you.